Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from JurisNet in New York, law publishers, and they've produced a very interesting series of books on arbitration. This particular one took our attention. It's called International Arbitration and Public Policy. It's been edited by two people, Devin Bray and Heather L. Bray. Very interesting book. When we looked at it, we thought this was a very important work for us to have some sort of view on. So we've written a review. We've given it the title, The Latest Thinking and Research in International Arbitration. And that's really what the book is about. Let's have a look at it first. It was a hardback. There's the front. You can see the front cover there. There's the spine. And then there's the back. That sets out what's about the book, about the editors, and then the people who've been the contributors, because in fact there are quite a lot of people involved in this book. Going to the back of the book, first of all, you've got an index. Now the index is slightly different again. It's not a particularly big index, but it's got quite a lot in it. And then you get from the index straight through into the work itself. Now let me just show you the work, because there are case law matters. You can see that you've got footnoting at the bottom, which is important, and you do have actual numbering. The paragraph numbering is not quite the same that we're normally used to. You can see in the body of the book itself quite substantial footnotes at the bottom, but there is not that much by way of numbering. For instance, you've got right at the beginning an introduction to international public policy by Lord Goldsmith, Queen's Counsel, which starts the book off, and again there's a little bit of footnoting at the side. There are various subheads, the basis of public policy. You can see the various areas going through just in Lord Goldsmith's argument, and then a conclusion at the end, and then going on. If we go to the front of the book, there's the actual front page there. Then you've got a summary of the table of contents, which you can see there. It's got the names of the people who've contributed. Then after that you've got the contents in more detail, and then you've got after that total number of 10 chapters. Then you've got detail about each of the editors, and then detail about each of the authors following it. Quite a large number of people. I can't go through all of them, unfortunately. And then, as I say, there's a foreword written by the two editors, the Brays, and then you go straight into Lord Goldsmith's article and so forth. So basically it's a collection of articles, if you like, in some respects, very well argued points which are made. Very interesting book indeed, part of a series from Juris, which we have reviewed, and this one I've found particularly interesting. This is what we say anyway. The book's been published recently by JurisNet, which is a limited liability company, and it's come from New York, and it's rather a valuable compendium in our view of some of the latest research and comment on, as the title indicates, international arbitration and public policy. Obviously the book will be of immediate interest to arbitrators, as well as all those involved professionally with the arbitration process, and that would of course include mediators and lawyers, particularly those specialising in comparative and international law, because we are looking at the international aspect here. And of course it's always a bit of a danger to do that, because you've got varying types of public policy involved. The individual contributors, and there are 13 of them in total, plus the two editors, hail from a diverse range of jurisdictions worldwide. Each brings a stunningly impressive portfolio of international experience in arbitration to the publication of this book. The international dimension here being of special importance for arbitrators confronting public policy issues, as public policy inevitably shifts and changes, often, if I can put it this way, quite arbitrarily, depending on the country or jurisdiction, and certainly the decade or the century involved, and in which it originated. And now, of course, that is an important factor to bear in mind, because what happens in one decade or century could very much change over quite a quick period of time, as people's views do change. So the editors Devin Bray and Heather Bray are respectively visiting scholar and research fellow at the Max Planck Institute for Comparative Public Law and International Law, and among an array of other academic and legal credentials are both barristers and solicitors of the Law Society of Upper Canada. And it's fair to assume that they and their team are amply well qualified to comment on developments in international arbitration that are practice orientated, in line with the overall approach of the book, which is arguably to link the theoretical with the practical. And as a team, the contributors shed much very helpful light on the practical considerations and practical problems that those involved in this complex field are likely to encounter. Now, the articles contained in the book originally appeared in two Swedish journals, that's the Stockholm Arbitration Report and the Stockholm Arbitration Review. Here they're grouped into two main sections. The first offers an overview of public policy, mainly transnationally and also in the United Kingdom, and part two, for the most part, shifts the focus to more or less specific issues that have emerged as a result of the ways in which public policy has been interpreted and applied in various jurisdictions worldwide. That's including the United States of America, Sweden, Switzerland, Ukraine and East Asia, primarily Malaysia and Singapore. Let me conclude with just this final observation. Public policy, always a difficult subject to pin down or define, has been variously described as a body of moral or social or economic principles which prohibit anything which can be perceived to work against the public good. This book, we think, offers a range of perspectives as well as practical insights into what is often thought of as an abstruse subject, but vital to the understanding of arbitration as it's applied within a number of different contexts. And anyone involved, therefore, we think, in international arbitration, which is a growing area, should get a copy of this book. We certainly found it very helpful, and I'd like to thank the editors and the contributors very much indeed. There it is again, front, hardback, back, and you can just opening it in the middle. You can see, here we go, this is International Chamber of Commerce case, for instance, is highlighted there. I did find it quite interesting to see the way in which the book is actually structured, because you do have the various parts, public policy starting off as an overview, which again is interesting to try to get some feel for where we're actually going. There's the actual contents, just to remind you again of what you've got. You've got quite a very interesting variety of comments spread over the 10 chapters. Anyway, thank you to the Brays and to the publishers, JurisNet, very much indeed. A lot of work's gone into this. It's a valuable contribution to what is the continuing debate on where we're going with international arbitration. Thank you. Do have a look at our reviews on the web and in the journals. Bye-bye.